Tony Greenstein, the jury has returned majority verdicts, and all but one of the Palestine Action activists on trial in Wolverhampton for planning to damage an Elbit Systems weapon factory have been found guilty too by an 11-1 majority. Now, Tony's on the call. People have said, "Oh, don't get him on the call because he'll get in lots of trouble." And I've written to him, say, "You sure you want to come on? You're not going to get in trouble for speaking out?" And no, and I think we all know Tony. He said he's coming on. Here he is.
Hi, hello everyone.
Couldn't stop you, Tony. You said you're coming on, whatever happens. Can you tell us what issues you feel need to be raised about this case where you've been found guilty by 11-1, and you could be facing a sentence of jail, couldn't you, for this?
Yes, absolutely. I mean, the main issue, and it's not just, of course, in this trial, is there is a determined attempt by the government and the judiciary, in essence, to nobble juries, and it's really part of the overall attack on the right to protest. We've had the Public Order Act, which was rushed in before the coronation in order that the Met could do what they did with the coronation protesters. But the key case was the Colston verdict, you'll remember, when the jury acquitted the defendants of criminal damage because they said that proportionally they had a lawful excuse for what they did.
Right.
That was appealed, not the verdict, but the ruling by the judge allowing that defense was appealed to the Court of Appeal under Ian Burnett, an extremely reactionary judge, the one who ordered Assange to be deported. And they said, except in the case of minor criminal damage, you could not use lawful excuse or the proportionality arguments under the European Convention of Human Rights, or indeed any other defense, in order to justify what you are doing. In other words, anyone who damages anything like an Elbit factory is guilty of crime. It's got nothing to do with politics. And you know, I mean, this goes back. I mean, I watched a BBC reconstruction of the trial of Emmeline Pankhurst in 1912, and the prosecutor told the jury that suffrage is not the issue. It is the criminal behavior of the suffragettes and their incitement to partake in militant activity at which 54 windows were broken. That was in Oxford Street. That is the issue. So, I mean, these things have happened before. I mean, they're not new at all. And we're seeing it again, that the courts are acting at the behest of the executive to clamp down. And this really goes back to an ancient case called Colston. I don't know whether anyone's heard of it. 1670, when the judge locked the jury up for 2 days and nights without food or water, fire or whatever other comforts, until they returned a verdict, and they refused. It was the prosecution of William Penn, the famous Quaker preacher, and William Mead. And from then on, it was accepted that a jury had the right to bring in its own verdict, regardless of the case of the prosecution, regardless of the evidence, if they thought it was unjust. And there are a number of judges who backed this up entirely. I mean, for example, Heather Hallett was a member of the Court of Appeal from 2005 to 19. In a Blackstone lecture in 2017, she said, a jury may refuse to convict in spite of the law and the evidence because it concludes that the law is an unjust law. They can see the jury making a protest as the public and as to what they see as an unjust law, an unjust application of the law. And that's been repeated time and again. There is a right of a jury to decide, if you like, that they will rather see justice than a narrow technical interpretation of the law, because we know that the law is not applied equally. Boris Johnson can get £100,000 for his mistress, Jennifer Arcuri, whose business was not even in London but California, and no one has prosecuted him. Or the Met refused to even investigate Johnson's drinking breaking of the lockdown regulations until they were forced to. And even then, they only investigated 1 out of 10 parties he attended. So we know that the law is not applied equally. And therefore, those who talk about the rule of law are really missing the point. There is one rule, one law for the rich and one law for the poor. And so there is this determined attempt. And we've seen it with climate protesters in London. 3 or 4 of them have been jailed for 7, 8 weeks for contempt of court, simply because they mentioned the words climate change. In other words, you cannot explain why you did what you did. You cannot explain your motivation.
No.
And motivation goes to intent, of course. If you're intending to cause criminal damage, then the jury isn't allowed to understand why you did what you did. So, I mean, it's a democratic issue at heart. And that's really what it is about.
It's shameful that you're not even able to speak out, and you get contempt of court if you said anything.
Yeah. I mean, Amy Pritchard and David Nixon and one other, they had 7 and 8 week sentences by Cyrus Reed simply for mentioning the words climate change. In other words, they could say nothing about what they did and why they did it. And that, I mean, last week there was a protest by 24 jurors outside the Inner London Crown Court where Cyrus Reed sits, holding up the plaque, because there's a plaque on the wall of the Old Bailey. It's a Colston plaque, and it pays tribute to the jurors who refused to convict, despite the fact that the law said they should convict, because William Penn was guilty of what he did, because that's what the law was, but it was an unjust law. But now they're saying you cannot break an unjust law, that juries have no right to decide according to conscience. So this is a political thing, and we have to take note and we have to fight back, because otherwise our democratic rights are being stripped, our liberties one by one, slowly but surely. And under this Tory government, we have the anti-trade union laws, which are being brought in very soon. We've had the Public Order Act. We've had successive acts, all of which Labour hasn't opposed. Starmer did not oppose. He ordered Labour MPs to abstain on the Public Order Act, which allows serious disruption orders. So it prevents people even getting to a demonstration, which is what the Met did when they arrested the coronation protesters. So yes, we have legislation on the statute books now, which any police state would be happy to use. I mean, that's what it's amounting to now.